Hello, Alison. It's very nice to see you again.
Hello, likewise. Glad to be back.
Well, and we keep saying it's our last episode, but honestly, this was a hit. And it's again by popular demand. We have another bonus episode that we're recording just because we got a lot of comments, people asking and requesting that we record. They want to hear from you on a very specific topic that kept coming up, and that is how to prepare the client to testify, help the client present his evidence in a credible and believable way. Although I do have to caution, and I know you're going to be doing the same thing, is that your client still at the end of the day has to tell the truth. He cannot lie on the stand. So if something happened, and he's going to have to say that. There's no changing that. And we're
Right,
going to be saying that you're going to have to lie about that or change that. But then
right.
it's how do we do damage control, I guess, in that case. So let's
Yeah.
start, Allison, and talk about how to prepare the client. And we have some,
Bonus appearance from Gus the
yeah,
kitten.
furry friends. Yes.
Yeah. All right. Back to regularly scheduled programming.
All right. So what is your advice here? How do we start?
I mean, the first thing is, and this goes in part, obviously, to the preparation of the client, but also to the other issues that we've talked about, is start early. Don't leave it to the last minute. And that's important for a couple of reasons. One, sort of unrelated to your client testifying, but that's how you find out about 276 and 278 and all those things that you have to file well in advance. Um, but also our clients tend to be horrendous witnesses and require a lot of work. So don't leave it until the close of the Crown's case to sit down and say, "All right, let's get ready for tomorrow when you're on the stand." This is the sort of thing that can take weeks, months, even sometimes to prepare. So don't leave it to the last minute is rule number one, I'd say.
Okay. Um, but then once you start preparing, so what are some of the first things, let's say, that you have to do when you're starting with the client? Like, for example, do you put the client first and tell him, okay, go ahead, just tell me the story. Let me hear you say it, let's say, for example, and then we'll go back and see and work on some points, or what is your approach?
Honestly, it depends on the case. Sometimes, because as you said, we can't, I mean, Lord knows clients, I'm sure, lie on the stand all the time, but we can't put them on the stand if we know they're going to be lying, which is
Right.
a bit of a distinction. So, there are cases where, yeah, I just have them in the office and say, okay, tell me what happened.
Yeah.
There's cases where, tactically and ethically, um, I sometimes think it's better to wait until we've got the disclosure, let the client look at it, absorb it, let me explain to them what the disclosure says, what the issues are, and then say, hoping that it will resonate in their brain, now tell me what happened, so that they know the case they're facing before they start. So it sort of depends, because if you, as you said, you cannot have a client, you know, confess to you and then say, all right, and put him on the stand, to deny it. That's unethical, and we can't ever let the our
Right.
clients or any of our witnesses mislead the court. So, um, you have to sort of have a bit of a sense of the case and go case by case, whether you ask them to, barf up the whole story the first day you meet them, or whether you think it's best to hold off and wait until you've got some disclosure to review and sort of go through it with them first.
Mhm. Now, one common problem that I see almost invariably with clients in these particular cases, Allison, um, whether it's domestic or sexual assault cases, clients always have this misconception that if there's no video, no photo, no physical evidence, then the case really, there's no case against them.
Yeah.
And I find for a lot of people, it's difficult to understand that words is actually evidence. Like what the
Yeah.
complainant is saying, when she's saying that he sexually assaulted her, this is evidence. And if the judge believes that, and rejects his evidence, I mean, that's not going to be good for him. So I find that sometimes clients don't understand that concept and they just say, well, let her say whatever because I mean, it's only her words and it's not going to have any kind of value. And I feel like that sometimes has an impact on how they testify because they don't feel like words alone are going to constitute
Yeah.
evidence.
You've got to be we hear that all the time. You've got to be um blunt and brutally honest. Like leave the legalese and lawyer talk. I never speak to clients and legal mumbo jumbo
Yeah,
and legalese. I speak plain English in the clearest of possible terms and tell them like it is. And that's probably the most common thing we hear all the time. And I get like mad. I'm
yeah,
not necessarily nice all the time. And I say, you idiot.
yeah,
99% of cases rise and fall on the words of a complainant and nothing more. So, and usually there's some F-bombs and other things in there as well.
yeah.
So like be brutally honest. Don't tiptoe around it. Just you've got to be sort of forceful and blunt and clear about everything when you're speaking to a client generally, but specifically when they've got nonsense in their heads like that, you got to make sure that they get it.
Now, I think one of the challenging types of defenses are when the client denies, he says it didn't happen, but his version of what happened is crazy. Like it doesn't make sense. And it's like, oh no, like she was consenting and she did all kinds of wild things and crazy things and and then when she testifies, she's like, no, none of that happened. Like, this is insane. And I think that's kind of the sense of what I was getting from the questions. It's in this type of situation where the client's version of events is unbelievable. He denies the
Mhm.
allegations, but what he has to say is a little bit difficult to believe. Then what do we do? How do we prepare him in this case?
First of all, same thing. Be blunt. Like
Yeah,
clients all the time will, give me their story and I'll tell them again, there's usually a lot of expletives involved,
yeah,
but that's bleeping ridiculous. There's no bleeping way anybody's gonna believe that. I yell, I scream, I make it clear. If I were the judge, your butt would be going away to eat cheese sandwiches for the next 10 years. So you better rethink all that nonsense you just told me.
yeah,
Because normally, I mean, sometimes truth is stranger than fiction, but normally when they're feeding you such ridiculous stories,
yeah.
it's because it's not true.
Mhm.
So be clear and just make sure they understand that nobody is going to believe what just came out of their mouth in your office. And by the time they come back for the next meeting, they better be ready to fess up about exactly what did happen, right? Because you're not encouraging dishonesty by doing that. You're encouraging them to go and think about that nonsense for a little while and come back and tell me what actually happened because I don't believe a word that just came out of your mouth. So you don't necessarily need to just take the first absurd version of events they give you and accept it as what their evidence is going to be. Be blunt. Say they're not going to believe that for this, that, and the other reason, whether it's from the disclosure or common sense. Um, and sometimes the best way, I think we've talked about this on another episode, but the best way for any client preparation, but including when it comes to things like this, is to bring in an outside body, your sweet mate, your partner, your whoever, um, to come in and be the crown and cross-examine them. And that tends, then they really get it. Right? Because sometimes we don't necessarily feel, I mean, to say, I have no issue, but often it's difficult to sort of be confrontational with clients, right? Like that can be uncomfortable. Um, but if you bring in someone else to be the bad guy who A is hearing it for the first time, like the Crown or the court would be, and therefore has a much more helpful perspective in many ways, but B doesn't have that relationship with the person and has no problem being as blunt as they need to be in cross-examination. That's the whole point of it. Um, that really does tend to get their attention. There's been plenty of clients where I can yell and scream and tell them they're idiots until I'm blue in the face to no effect. But then when somebody else comes in to pretend they're the crown or the judge, ooh, then they get it suddenly. Why? I don't know, but it works. It's a very powerful tool.
Well, then the other difficulty is um, when the client really wants to testify and you don't think it's a good idea for them to testify because sometimes when the story is actually so bizarre and so crazy, and you can tell, I mean, sometimes it's bizarre, but there is some kind, it could make sense. So you're
Hmm.
like, okay, we can work on this. And, if you work on your presentation, the way you present, it could work maybe with a jury or with a judge alone, depends on who the judge is. But sometimes it's so wild that honestly, it's better for him just not to say anything and just to try to attack the credibility of the complainant. But what if the
Yeah.
client is like, no, I want to give my side of the story? And I understand we're getting here into some ethical issues
Yeah.
that we need to get instructions. But I mean, like, does it have to get to a point where you may potentially have to get off the record at that point? Especially if we're not too close to the trial.
Um, I don't know. I mean, as you know, it's we get to make a lot of decisions. That's not one of them. It's always the
Yeah.
client's decision. And I've certainly been involved in more than a few appeals and mistrial applications and such where, at least according to the accused, their lawyer at the time just refused to call them. And that's going to be a successful ground of appeal if you convince the court of it 100 times out of 100. So it is ultimately their choice. Make sure you get written instructions. Um, I don't know. I mean, if you know your client's going to mislead the court, then you have to get off the record.
Mm.
I don't know if it's ever grounds to get off the record just because your client is going to doom himself. I mean, most of our clients, maybe most is a little harsh, but many of our clients are going to, you know, doom themselves when they testify, and that's just the reality of this job. So I don't know that that's ever a basis to bring a motion to get off the record. Um, just make sure you get written instructions. Ultimately, it is their decision. Um, and at the very least, if they're going to tell a banana story, make sure they tell it well. At least work on the presentation side of things, right? Because I mean,
Mm.
I have had cases where I said to my client, "You are 100% going to be convicted if you get up on the stand and say that."
Yeah.
And they said, "Well, I'm going to get up on the stand and say that." So at least we worked on how it was delivered,
So
and
let's,
they,
yeah, and
yeah,
let's talk then more specifically about that because I
yeah,
think that's another important, especially if it's a jury trial, because
yeah,
sometimes that's how you can actually persuade the jury. It's in the
exactly.
manner, the demeanor, and because that's the tricky part, especially in sexual assault cases, is that
Mhm.
many times the complainant, on the other hand, is going to be very nice, very likable.
Yeah.
She's going to become emotional. She's going to cry. That's going to play with the jury or judge's affection
Mhm.
and emotions. And on top of that, if she's at least consistent when it comes to the assault itself, the sexual assault, putting aside the inconsistencies on other things, but if
Yeah.
she is adamant, he sexually assaulted her, there's no way she consented to that, that's powerful evidence against the client. So,
Yeah.
what can we do to make the client really prepare on the delivery? And especially when we know that we're going to have a complainant who's going to be very likable, very consistent. And honestly, there's no reason for her to invent the incident.
Right. I think that's the part that often takes the most work is the
Yeah.
the presentation side of things. So while rehearsing your story, so to speak, um, shouldn't actually be that hard. If they're telling the truth, um, it shouldn't require, 10 different, practice court sessions. But for things like demeanor and delivery, it can. I've had clients where, I mean, they've probably spent 20 different Sunday afternoons, I mean, not the whole afternoon, but sessions in my office practicing. And we just go through the same thing every time. And it's the basics, like um, not denigrating the complainant, being polite, um, not answering questions with questions. Not saying things like, well, why is that relevant? Not swearing, all of the basic stuff. If they can cut that out of their testimony, um, at the very least, you may have, it's one of my favorite submissions at the end of he said, she said cases, particularly when the client's a disaster. Um, Your Honor, this may be one of those cases where you throw your hands up at the air and in the air at the end of the day and say, I just don't know what happened, right? You've got two believable witnesses. Benefit of the doubt has to go to the accused. So if they deliver it well and are polite and likable, even if what they're saying is bonkers, that'll give them a shot at least.
Mhm. Um, on the rehearsing and preparing, now, one of the things that sometimes judges do comment on and they don't like is when it's too rehearsed. When it looks
Yes.
like it's too rehearsed, then it becomes theatrical, it looks fake, and they don't believe them, although they are telling the truth, though. But
Yeah.
because it's too, so there's, I think, a fine line here and a balance between, yes, you want to prepare them, but not prepare them so much that it looks fake and it looks like they made up the story and that the
Yeah.
judge doesn't believe them. And I think that's also one of the challenges in these types of cases. So, what is the proper way to achieve that balance?
It is. You're 100% right. In terms of the preparing the chief portion of things, that's where I think you run a risk of that happening. If
Mhm.
you just sit down with your client with the same, you draft out every question of your chief and you just go through the same script over and over and over again, it may well end up sounding like that. So I try not to do that. I try to, make it more of a sort of off the cuff conversation every time we're going through their evidence, right? So that it's not the same questions every time. It's not the same order every time. It's just, I'm just sort of asking it on my feet as we go through a story, and my questions are just sort of following from what the answer has been. That way they tend not to get stuck into that, rut of this was the question, this is what I was supposed to say, and that can sort of play
Like
in
you
their
don't want them to be memorizing and that it
right,
shows that it is
exactly.
memorized and it's scripted and they're
Yeah.
just expecting and anticipating what the next question is going to be.
Exactly. Yeah. So don't go by the same script every time.
Yeah,
Just make it a conversation
yeah,
every
yeah.
time. It's less of a risk, like have them cross-examined by somebody as many times as you need to, because that tends to be different every time, and there's less of a risk of that. But be careful about just going through the same script over and over and over again.
Also, another thing that I've noticed sometimes is, and unfortunately, you can't really predict how they're going to be acting inside the courtroom because you're preparing them usually in your office. I mean, I don't know if you prepare them in a courtroom, but I don't think many of us have the time or the capability to do that. But surprisingly, I've had clients who, when they're on the stand, they're looking at the judge. They're like, you want it to be a conversation, but to what point do they have to actually talk to the judge, turn and sit and address them? I mean, it
Yeah.
becomes weird when they do that. Sometimes, I mean, it's nice if they feel comfortable, but not too comfortable that, like the conversation is with you, not with the judge. So
Yeah.
I've had unfortunately clients, and I couldn't anticipate that. Like now, I know because it happened. But when the first
Yeah.
time it happened, I was like boiling inside and I just like didn't know, like it was just
Yeah.
so weird, let's just say.
It's funny how our list of things grows as clients do stupid things, and you just add it to the list of things to discuss with clients. I got a guy that showed up at his trial one day in a t-shirt that said convict on the front. Hey, so now we know to add, don't wear jail clothes
Yeah.
to your trial to the list. So it's I find it calms them down if you tell them just look at me, pretend there's nobody else in the courtroom. Just look at me. That's who you should be looking at anyway. Don't worry about what everybody else in the courtroom is doing. That's something I do tend to tell them pretty regularly, just because it calms them down. They're
Yeah.
often sort of nervous about speaking in front of all these people, so that'll help.
And sometimes, Allison, what happens, a little bit related to what I was just talking about. Sometimes your client will surprise you and do something that you really, or say something that just for the first time is coming out of nowhere that he never told you before, or you never anticipated that he would say.
Regularly.
Yeah. And
Yes.
it comes out for the first time while he's testifying on the stand. Um, I guess here we're doing damage control if it's bad. Like sometimes they'll say something and it's good, but obviously we're here concerned about the situation where they're saying something for the first time and it's really very bad for them.
Yeah. The Truth is Stranger Than Fiction, one of my favorite submissions ever. And what I find myself, I think I've said is that every jury closing ever, because clients always say something stupid, and we often tell them to like admit they're false, right? That's one of the things we don't pretend you're, a Boy Scout up there. Be honest about XYZ things. And I will almost always say to a judge or a jury, um, look, Mr. Whatever testified that blah, blah, blah. If he was trying to pull the wool over your eyes and lie to you, he wouldn't have said that. That doesn't help him. I say that in like every trial, almost, at least every jury trial. Um, and it's effective. Like I see jurors nodding all the time, and most of the time I'm saying that honestly. Like for example, a client at a murder trial who's a drug dealer and admits to being a drug dealer. No, you say he wouldn't have admitted to being a drug dealer if he was trying to, lie to you about what happened. You can often sort of use that same line of logic when a client says something really stupid on the stand that hurts their case. If he was lying, he wouldn't have said that clearly because it
Right.
was so stupid, right?
Yeah.
Yeah,
There's absolutely no reason for him to be hurting himself.
exactly.
Uh, in terms of cross-examination, so I know you said we've said that before. I mean, this is something that you mentioned in the episode that we had specifically on preparing the client. Um, have him be cross-examined by someone other than yourself.
Yeah.
Um, but then, what advice do you give the client though on how to respond to the Crown's questions, on like the style or the demeanor with the Crown?
Be um be polite.
Yeah.
Don't be rude. Don't be argumentative. Don't answer their question with a question, um, which they do all the time. Why were you wearing a purple shirt, sir? Why wouldn't I wear a purple shirt?
Yeah.
Don't say that. That's the example I always use.
Yeah.
Just say because I like purple shirts, right? So, um, don't say more than you need to. Keep your answers concise. Don't get verbal diarrhea because if
Yeah.
you get verbal diarrhea, then you're going to open up a whole host of areas for the crown to go at you. So be short, be concise. Just say what you need to say to answer the specific question and wait for something else to be asked. You don't need to, read the whole dictionary. You could just read the one definition.
Another issue that comes up, and I know that this is something that has been also addressed in the case law, and we have case law specifically on this issue, is obviously the client will be testifying after the complainant gives her evidence. And then there's always this problem that judges will, we've seen some decisions, will comment then that, well, the accused was adjusting his evidence to what he heard from the other witnesses at the trial. Um, and the thing is, I mean, he's listening. Of course, he's going to have to respond to some of the points that are raised. And
Right,
we do that in submissions, right? If the Crown says something and I'm going to be making I'm going to address that and
right.
talk about that. So, but I find like judges, I mean, this is a point that comes up usually where they respond to something or they adjust to what a complainant is saying. So
Yeah.
how do we deal with this issue?
I mean, first of all, tell them not to.
Yeah.
Like just answer the question that I asked you, and you can sort of if you're guiding them with your questions in chief, you can hopefully avoid that happening. Um, and so instead of just, saying, okay, tell us what happened that day. Try to be a little more step by step through the process with them in terms of the questions that you're asking them in chief. And you can hopefully then avoid just this long diatribe in which, amongst other things, your client starts just sort of talking about the evidence. Um, Tell them not to. I do not ever want to hear you say, well, she testified that and she testified that and the video that shows it. That's my job. And
Yeah.
I make that clear to them. I
Yeah.
just want you to listen to my question and answer my question and don't say anything else. Um, and if there's just to sort of avoid that to the best of our ability, I will often say, just so at least it's clear to the judge that that's not what he's doing. I will say, well, sir, you heard Mrs. Whatever testify that blah, 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 and then get them to, give their sort of um, side of things, or you heard her testify that X, why don't you tell us what happened with that, or whatever. So if in your question you're making reference to the evidence, then it's coming out that way because of the way you as counsel asked the question, or because you asked the question, rather than because it's something that your client's just
Right.
offering.
Justin.
Yeah. And then it doesn't fall on them.
Okay. Um, and then how do you address your client's evidence when you're making submissions, Allison?
Uh, I won a murder trial once, and I'm convinced the only reason I won that trial is because I spent about 2 hours closing to the jury, calling my client an absolute idiot, a moron, a buffoon, the stupidest man alive. Like I went all out, because I had to explain some of the absurdities that came out in his
From the client.
cross-examination. And yeah, I just called him dumb for 2 hours, basically, and he was acquitted because it. Anyway, so sometimes you just have to throw your client under the bus, honestly, in
Okay.
submissions, and that's the best way to do it. And I've done it many times and successfully so. So don't be afraid. You don't, don't you just tell your client, look, I'm going to have to be a little unkind to you here. And so if you have to call them an idiot, call them an idiot. It doesn't mean that they're lying. It just means they're not the sharpest tool in the drawer. Um, but don't don't ignore it. Like if there's a big red flag in what they said, address it head on in submissions. And sometimes, you just have to use the things that the Crown uses all the time about the passage of time and fading memories and that sort of thing. Maybe they've got, drug issues in their background or mental health issues in their background or whatever. That you can sort of rely on to explain things. So every case is a bit different, but if you have to throw your client under the bus, do it. Yeah.
Well, okay, now that's a good point because it does remind me of something that I encounter a lot because I do represent a lot of accused who are from an ethnic background, especially Middle Eastern, because I'm Middle Eastern.
Yeah.
Um, in these types of cases, the sexual assault cases, I find Middle Eastern men can be a bit more difficult.
Hmm.
Um, First of all, they get really angry. They get a lot more reactive, a lot more emotional in their emotional in an angry way. They also, unfortunately, sometimes have some stereotypes uh, that they will express during their evidence. So maybe if we can touch on this point of the distinction also, depending on the background of the accused, because I find um, there are like some accused will, first of all, they just don't accept the fact that they're in court, they have to testify, and that they have to defend themselves against
Hmm.
an allegation of sexual assault. And it's just that what my concern always with especially Middle Eastern men is I don't want them to use terms that are derogative or negative
Yeah.
terms about the complainant, and they will sometimes do that, and that's really dangerous for them.
Yeah. Big time. I mean, that's where I think the preparation side of
Mm.
things comes into play. If you yell at them enough going over things, they're likely to get it eventually. And just be clear, like it, buddy, if you say that word in court, your butt is going to jail. Like be clear, because it's true in all likelihood. And sometimes you have to be, not sometimes, often you have to be blunt with your clients to really get the message across. So don't be nice. Don't tiptoe around it. Just be blunt because they sometimes just need to hear it in the clearest of terms. That's what one of the things that clients tell me they like most about me is that I'm blunt. I talk like a drunken sailor sometimes. I swear a lot. I'm blunt. I make my point in clear terms that they're going to understand, not, legalese. And generally they'll get it, but you have to be blunt and clear and explain exactly why.
Okay.
Yeah.
What else, Allison, do you have as tips that lawyers should be mindful of when they're preparing their clients?
Um, I don't leave it to the last minute.
Hmm. Yeah.
I think that's something that because we're all so busy, we're all worried about whatever we've got in court tomorrow rather than the trial that we've got um 2 months down the line. But but don't do that. You've got to be cognizant that sometimes because it's these sorts of cases more than any other, I think, where our clients are most likely to be testifying.
Yeah.
And when it's a case that's likely or at least a reasonable possibility, don't leave it to the last minute. I think that's the most important thing because some of these clients are going to take a lot of work um, and are going to take some repetition and challenging afternoons in your office explaining to them why they are going to be convicted if they say what they just said.
Yeah.
Um, and sometimes it really is, just practice and hammering the points home. And um don't just tell them, you know, I don't believe that or that's not going to work or whatever. Show them, for example, in the disclosure why. Fairly recently, I had a sexual assault case where um, there was DNA, where there wouldn't be DNA if what,
Yeah.
there had been some sort of activity. And it just, the dude insisted, he didn't know this girl, it never happened, blah, 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 blah. And I was like, I had copies of the DNA report and I printed off because I was so fed up at a certain point. I printed off like 30 of them or something. And every time we got to this point and he reverted back for whatever reason to it not happening, I would like throw copies of the DNA report across the aisle. I was throwing them everywhere. I was getting it hot. Like it was a scene. And but finally he got the clue that he couldn't just get up there and lie and say, I don't know this girl. That wasn't going to work. So like do whatever you have to do, but start early because sometimes these guys take a lot of work for the reasons, amongst other things that you mentioned, which is that it's not on video, there's no fingerprints,
Yeah.
therefore they can't prove anything. There's no case. That's the phrase. There's no case, and that's just not true. And sometimes it really does take a lot of work to get it across to them that they don't need any of those things.
I do want to mention though, there have been, I've had a few cases where unfortunately at the last time, at last, like very last moment and at the wrong time, they will change their version.
Oh yes. Yeah.
And they will say something that is completely different, puts you in a very bad situation because if it's this, if your defense is still going to be the same, it's okay. You're just going to adjust the story.
Mhm.
But sometimes it just entails a completely new defense. How do we deal with that when we're preparing the client and then last minute he comes up with, well, you know what, actually, this is what happened. I didn't feel comfortable telling you at the beginning, but now this is it. Deal with it. So how do we deal with it?
Yeah. I mean, I think if at all possible, seek an adjournment.
Mm, yeah,
You can say, you know, Mr. Whatever just brought something to my attention. I need a bit of time to look into it. And at that point, the Crown's case can go in. There's no reason to make a complaint and come back,
yeah.
5 months down the line or whatever. Put the whole Crown's case in, and then just ask for time before getting instructions on calling a defense, or electing whether or not to call a defense. I think that's the default position because um, that would make you worry what else is going to change if you
Yeah.
don't, put sufficient preparation into it. I mean, sometimes there's nothing you can do. That's on them if they were, um, going to be dishonest with you for so long. But I would say, if at all possible, ask to get the Crown's case in and then come back down the line to call a defense. That way you'll have some preparation time. There's not much prejudice to the Crown at that point.
Yeah. And is there anything in particular that you do when you're preparing your client for a complainant who's a child, or uh, very often in these cases, not just a child, but it's the accused son or own child? Is there anything in particular that you do that's a little bit different for these types of cases?
Um, Not really, to be honest. Other than, however emotional and upset and angry they may be, um, show empathy. There's for a child to make that type of allegation, they've gone through something. They've either gone through what they're describing because it's the truth, or there's been some other trauma, generally speaking, that's, caused them to say whatever it is they're saying. That's at least what I always preach to my clients. And you should conduct yourself with that in mind when you're cross-examining them. But also when you're helping your client testify. Tell them to come across as a loving, caring, hurt, upset father, um, rather than, just an angry accused who, wants their day in court to clear their name. Show empathy and come across like a caring dad who's worried about, whatever happened to your kid that caused them to come to court and say this sort of thing. I
All right.
think that's the best thing you can do.
And do you ever tell your clients to watch any kind of court TV?
I don't. It's just it's so unrealistic. In fact, I tell them, whatever you've seen on TV, that's not the way it works. Because that's why they all think it's American court TV shows that make them all think there has to be DNA and video and,
Yeah.
20 witnesses and whatever else. So I generally tell them, whatever you saw on TV, it's not true. And in fact, I usually tell them when we have this conversation about why there doesn't have to be all of these things, I usually tell them that's American TV nonsense. That's not true. That's why you all have this idea. So no, I don't. I tell them to go, if they really want to get an idea, I tell them if you have a day off or an afternoon off or whatever, go
Watch.
to the courthouse and watch
Yeah.
real court.
Yeah.
But for the love of God, don't watch TV and think that's how it's going to be.
Yeah.
Yeah.
All right. I think one last thing, though, that I want to ask you here about this point, about this subject, Allison, is how to control their stress and anxiety. Because, I mean, in fairness to them, it's extremely stressful. I mean,
Sure.
many of them are for sure going to go to jail for a long time if they are found guilty and convicted. How, like, I don't know. Again, I think it depends on the lawyer. Some lawyers have the approach that, well, I'm not your psychologist. I'm not going to give you any kind of stress management advice. I think there has to be some minimum. I mean, just in terms of anticipating that you are going to get nervous, you're going to maybe, like you're not going to be talking like you usually do.
Mhm.
So, in terms of just stress management, what do you tell your client? And especially if the client is a nervous person.
Yeah. I mean, tell them, first of all, the same thing that the Crowns tell their witnesses all the time, which is it really is okay. If you need a break, um, it's okay to ask for a break.
Yeah.
I tell them if you're going to get emotional, it's okay to be emotional. In fact, usually I encourage it.
Yeah.
Please ask for the Kleenex. Bonus points for that. Um, I tell them it's okay if you don't remember something. It's okay to say you don't remember. Um, don't feel like you have to answer. If you don't remember, you don't remember. If you don't know, you don't know. Um, I I avoid the constant repetition like we've just been talking about for that very reason sometimes because I find the really nervous clients are going to get to that, analysis to paralysis thing where they think, oh, Allison asked me this question in her office and she said to say this and then they get into this like
In
headspace that
their
turns
head.
into,
Yeah.
yeah. So I for particularly nervous clients, you might think those are the ones that need the most preparation. Sometimes it's the opposite because they're the ones that will get, analysis to paralysis on the stand. So you have to sort of take it case by case, but tell them exactly what a crown is going to tell their witnesses, which is take your time, listen to the question. If you need some time, it's okay to sit there and think for a minute. It's okay to ask for a break. All of those things that you hear at the beginning of a complainant's evidence. Make sure your client understands that those apply to them too.
Yeah. And very important, obviously, I know many of the lawyers watching this will already know this, but also tell your client. I sometimes forget, but I always then try to say it on the record. Remind them that once you enter cross-examination, that you cannot communicate with them. That's really
I
important.
forget
Me
every
too.
time. Every time. Yeah.
But it's so weird because then you're like, you want to remind them, you want to tell them, I can't, I prefer not to talk. You
Yeah.
can still talk, but you have to be very, very careful. I personally don't talk to them at all when they're in
Neither do I.
cross-examination. So,
Yeah.
but it's very important. Try to always remember telling them that when you're preparing, that once we start the cross-examination, I'm not going to talk to you and explain why. It's not because you're mad
Yeah.
at them because they didn't do well. It's because
Yeah.
the rules prevent you from doing that. So that's also
Yeah, exactly. No, that's so true. And I do forget every time and then have to tell them loudly in the courtroom as they're getting off the stand at the beginning of the break or whatever it is. So yes, 100%. Try and explain to them why.
Yeah, it's a rule that we have to follow, but you have to tell them they wouldn't know that, and you don't want to put that you don't want to stress them out because then they will want to talk to you, and then if you don't, they'll think you're mad at them. So you want to
Yes,
minimize the anxiety at this point.
exactly. Yeah, agreed.
All right, I think Allison's we covered quite a lot. I don't know if there's anything else that you want to um, address here.
We covered everything on my notes.
Yeah, I think so too. I think we covered quite a lot. And well, if there's any questions, obviously you guys, you know how to ask your questions and how to find us. It was really very nice to do this series with you. Thank you so much, Allison. Honestly, I think this is what made this my YouTube channel so popular. It's all this work that you did. So you also deserve recognition because this was an awesome series. I've had nothing but positive comments about it, and people just wanted more from you. So thank you so much for always giving your time. I know you're always in trials. So just to make it clear, Alison is always in trials. And so for her to be doing this is really very remarkable. So thank you. We're very lucky.
My pleasure. Gus's pleasure as well,
Yes.
wherever he went. Yes,
Thank you, Alison.
you're welcome.